Lawyers think that juries want to hear about who they are. It's none of that. You learn patience. You heard other cases. You chatted face to face with defense lawyers and insurance companies and judges. You're dealing with someone going to jail or maybe not, or a crime victim getting justice or not. You're in the moment, big time.
Welcome to Celebrating Justice, presented by the Trial Lawyers Journal and Cloudlex, the next-gen legal cloud platform built exclusively for personal injury law. Get inspired by the nation's top trial lawyers and share in the stories that shape our pursuit of justice. Follow the podcast and join our community at triallawyersjournal.com. Now here's your host, editor of TLJ and VP of Marketing at Cloudlex, Chad Sands.
Welcome back, friends, to Celebrating Justice. In this episode, we hear from trial lawyer Alan Ripka. From the Brooklyn DA's office to the groundbreaking Stayskull Act, to how the tragic death of his brother led him to a life of law, Alan's career is as entertaining as it is inspiring. To get to the stories, I asked him, why did you want to become a trial lawyer?
I was actually in college, and of course, growing up in Queens, my parents wanted me to be a doctor or, of course, a dentist. That was the way it was back then. Of course, I believed it and believed I wanted to be and needed to be. And when I went to college, I actually majored in pre-med biochemistry, things of that nature. And unfortunately, my brother, a week before his high school graduation, went on his graduation ski trip and got killed on Sugarbush Mountain. Of course, being an idealistic kid, I thought after that, because of how devastated my parents were, that I could help people who had kids or brothers who died in ski accidents by becoming a lawyer, a accident ski attorney. Of course, there's really no thing. And I changed my course immediately, went from going to medical school to going to law school, believing in my cause, and thought that I was best suited to speak on behalf of people who couldn't speak on behalf of themselves or didn't know how or didn't have the license or the passion or the ability to cut out emotion and see things objectively, issue by issue. And thus, that was the origin of why I became a lawyer. Although after law school, I was lucky enough to get a position as an assistant district attorney in Kings County. I remember I went through 5 interviews. It was unbelievable. And there was 32 of us in our class. During training, one of the attorneys that were very experienced came into our little group and said, "We've got this case. Who wants to try it?" I raised my hand. And as a result of trying that case as a complete newbie, I progressed very quickly through the different divisions at the district attorney's office. And I was trained incredibly well, nonstop. Unlike graduating law school and joining a firm where it's sink or swim, I served the public. I was trained well. I was constructively taught. People sat through every trial, through every jury selection, every night going back to the office, going over what I did right and wrong. After the district attorney's office, I went into the private sector in 1992 and have been doing this, representing injured parties on the plaintiff side. And my training and background allowed me, my passion, my ability to identify issues, to become, luckily for me, the trial lawyer with the trial firm that I have today.
You started out on a path to being a doctor, which is actually what a lot of trial lawyers tell me. I think it's that innate feeling of wanting to help people. The tragic death of your brother actually was the catalyst for you going to law school. And was your family able to bring any litigation with that?
Yes, there was a case. It's so long ago that I don't even remember if it was confidential, but it was a month before my 21st birthday, a week before my brother Robbie's birthday. He died on February 12th. He was buried on February 14th, and his birthday was February 20th when he was going to become 18 years old. At that time, mountains were not required to have foam padding around the bars that hold up the ski lifts. And he was on the bus going home with the entire graduating class after the entire trip was over. And there was a bit of a snowstorm. And a lot of the kids said, hey, let's go out and have one more run since we're delayed here for hours. And while going down, a teacher was giving a lesson to a young 7 or 8-year-old. The child had fallen, so Robbie, to avoid the child, turned to the left, which headed him into the ski lift, and he died as a result of the impact. And of course, my parents, there's a group called Compassionate Friends, which are people that have lost people for all kinds of reasons, whether you have a child who committed suicide, or drug-related, or criminally related, or an accident. And you go into these little groups to help you get through life. They did that in New York for parents who lost children as a result of accidents. 30 years maybe of group meetings, whether they be in a church or a synagogue or a bank conference room, wherever they can get the meetings in New York and Long Island, Queens. And they did that forever, supporting one another. So there was some litigation. There was some resolution. At that particular time, I couldn't even begin to understand what it was. But from a liability standpoint, it turned out that it was a very difficult case. You sign away all your rights when you sign these things saying that you understand it's dangerous and that there's no foam or no padding. But from then came now laws in many states that require safer conditions to the extent they can be.
Advocating for change in society, pretty powerful. You've been doing this a long time. You're in New York. There's a lot of trial lawyers in New York, super competitive. What makes you unique from other guys out there?
Yes, there are many, and many that throw themselves in there, believing that if you get a personal injury case, and because you get a third, somehow or another you can make money, and somehow or another you can do it. But that's the furthest from the truth. There are not many of us left out there. And by that I mean that started very young, had incredible training. At the time, we were all in court. We were in courtrooms all day, every day, in every county. There was no remote. There was no Zoom. It was hand-to-hand combat. You had 100 people in a room for a preliminary conference, for a compliance conference. You waited your turn till sometimes after lunch. You learned patience. You heard other cases. You chatted face-to-face with defense lawyers and insurance companies and judges law secretaries. On top of all that, if you gave public service, in my opinion, you're a different kind of lawyer. There is no training that is more unique, more intense than public service. You're thrown into a courtroom with 40, 50 files on a desk every single day, dealing with 40 or 50 different lawyers on different types of issues, with judges who want to move the calendar. You better know what you're talking about, because you're also dealing with people's lives. So we're not dealing with someone's car accident that has a minor injury and whatever happens, happens. You're dealing with someone going to jail or maybe not, or a crime victim getting justice or not. You're in the moment, big time. And I think what's made me unique is, one, the reason I became an attorney. That passion resonates with me, and it doesn't fade because she's gone forever. Secondly, because of my public service and what I learned and trained with, and the incredible bureau chiefs and assistant bureau chiefs who saw something in me and were willing to push me, work me, criticize me to become better with their 40 years of experience. I was one of the lucky ones. On top of that, we're all born with different unique qualities. Mine is I have the ability to break through it all and identify the issue. What is going on specifically, not generally? What are we talking about? What's not in dispute? Let's get rid of that and just focus in on what is in dispute and understand what part of that we can come to terms with. It's grinding it down till the judge, the jury, the lawyers, the insurance companies all actually understand, what is it that we're quibbling over? This whole thing, just this much. Okay, now that we're there, how do we come to an amicable resolution? And that just requires hundreds, if not thousands, of fact patterns, of cases, of law, being a boss, of being in court, of trying cases, losing, winning. They are now few and far between. A lot of the older guys are retired and dying off. There's my sort of age bracket of 30 to 40 years. And I tell you what else happened. This COVID thing destroyed younger lawyers because from 2020, even until now, no one's gone to court. You graduated law school, or even if you had 3 to 5 years experience, you got stalled.
Right.
You need 15 years before you even have a scintilla of knowledge of what you're talking about. You need at least 50 trials before you can even say one teaching word to anybody, in my opinion. That's what makes me unique, but not because I'm better than anyone else, just because I was one of the lucky ones who had the education, the experience, the resources, and the wherewithal to move forward.
You talked about how you're able to identify what is really the issue that everyone's disagreeing on. Do you remember when, and then kind of getting everybody to accept that and discuss it? Do you remember in your career when you started figuring that out as kind of your strategy and putting it into play in trial?
Actually, yes. I was in front of Judge Justice Rakoff, one of the best judges on the federal bench. I was a young lawyer with a massively horrible case. A cab driver that I represented was on one side of the street in the Bronx, and a mail truck was on the other side of the street. And the mail truck went over the double yellow line and basically rolled over the cab, causing massive catastrophic injuries. They were horrible. And when you bring a case against the federal government, it's judge only. There's no jury. It's called the Federal Tort Claims Act. And Judge Rakoff was the judge. And we put this case in. One night at about 6 o'clock, we're all folding our papers up to leave. We had both rested. We both finished our cases, for those who don't know what rested means. And Judge Rakoff said, I'll never forget it, Mr. Ripka, where are you going? I said, the defense rested, Judge. There's no more evidence. I think we'll sum up tonight. And there we stood. I looked at the defense attorney. I'll never forget it. He looked at me. I said, okay. I had an orthopedic surgeon that had testified a couple of days earlier. I won't mention his name, but he was a strong guy, the head of a hospital here in New York. I started talking about in my summation about he had said he broke this and he broke that and he couldn't walk and these were the injuries and on and on and on, and they were horrific. Judge Rakoff looked at me and he said, don't you think that guy was full of himself? Don't you think that guy thought he was greater than God? And at that moment in time in my life, right there and then, I realized and I said, you are absolutely right. Doesn't every orthopedic surgeon think that they are the best and they're so verbose and they're this and they're that? And I agree with you. But, Judge, does it mean he wasn't telling the truth? Does it mean he wasn't saying it like it was? Does it mean that he didn't indicate to you each and every injury and how bad they were? Yes, there was a lot of noise in between, but let's talk about where he brought us to. And in my head, that moment, I'll never forget it. Alan, give in to what you need to give into. Bring the issue down to what it is, the injury. Get rid of everything else. Admit when you're wrong, fight when you're right. That moment did it for me forevermore because of his statement and me giving into his statement, because, by the way, he was right, that I realized the best thing to do in litigation is tell defense lawyers and jurors and judges when the issues, the facts, or the law is not on your side, but tell them why your interpretation brings you to where you want to go. Tell them why you're willing to compromise, because you don't have the best case. And lock down the issues for the case, and that's sort of where it all began.
Was that first case you mentioned that you got as an ADA that you raised your hand and said, I'll take it?
I was an assistant DA for about almost 4 years. I was an intern in the office for 2 years, 1988 and 1989. Got the job at 89. I was lucky enough, that first case was a case where, and I love telling the story because in the district attorney's office, if you're a felony attorney, right, you know in criminal law, there are violations, misdemeanors, and there are felonies. There was a case where a guy was on his 7-year anniversary, give or take, with his girlfriend. They had lived together. And they were a couple, and they were both hardworking people in Brooklyn. And they were going out for their anniversary, and the guy pulled in front of McDonald's. He got out of the car, And he went around to the side where his girlfriend was. They weren't legally married. And she goes, I'm not getting out of the car. We're not going to McDonald's for our anniversary. You're out of your mind. And somewhat argument ensued. And he reached through the window that she had rolled down, grabbed her by her face, and he was wearing you've seen those lion rings, these big funky things, and they've got some sort of stones in the eye, whether it be emeralds or something like that. The thing hit her in the eye and blinded her.
Oh.
Obviously, he was arrested for assault, and it came into the district attorney's office. It was written up as a felony because she had such a serious injury. I guess whoever was handling the case at the time realized he couldn't show intent. They had been together. There was no criminal records, no domestic violence, no abuse, none of that. And you have to show intent. Intent means you meant it.
To get prosecuted as a felony?
Yes. You have to show that someone wanted to do this, meant to do this. They came down to us newbies, and they're like, who wants to try this case? Thinking that it's going to get lost. I raised my hand, and I have this case, and I'm sitting at my desk. All of our class, a lot of them are watching because we're like more of a fraternity and a sorority, like young lawyers. Oh boy, Alan's trying this case, that sort of thing. And I look back and think about how at that age and my maturity, I was an assistant DA, or anyone can be. There's a whole nother podcast. The guy took the stand to tell a story to the jury about how he didn't mean to do this. And I said, okay, I just stood up and said, how do I get the jury to believe? How do I get this woman justice? Remember, say, it doesn't matter who's watching. It doesn't matter that the bureau chief is analyzing you. Just do what you believe you ought to say and do. And I said to him, that ring on your finger, that lion's ring, did you get that as a gift? Yeah. My dad gave it to me. And you love it. Yes. You wear it every day? Yes. You're driving your car, you see it on? Yes. You don't even take it off when you shower. No. When you shave? No. It's a part of you. It's a part of your life. I bet you if anyone ever took it from you, you'd be real angry. I would. No one's ever taken this thing from me. You admire it every day? Yes. Thank you. Gets off the stand. In my summation, I told the jury, he knew that he had a weapon on his hand. He knew that ring, whether it's going to hit her cheek, her nose, her ear, her eye, he was well aware of it. Jury comes back, guilty.
The ring he loved so much actually sealed his fate.
And that he knew he was wearing and could cause damage.
I kind of squeezed two ADA stories out of you real quick, but let's get to, and you talked about your brother's case, obviously, and I know it's hard to choose one, but can you share a story from your post-ADA years about a case that had a significant impact on you?
Oftentimes, I guess when you do what we do, it's the person you meet, the injury that they have, and the impact on their life. And when you get to know them is what I believe. I could say this now, 36 years later. Because if you look back and think about what did it all mean? What affected me and what didn't? How much of it was my job? How much of it was my soul? How much of it was I born to do? And of course, it's a business and you're a professional and you prosecute every case that you're lucky enough to get to help all people at all times. And I sort of treat them equally. And some people think that's my weakness because I take a case that may not be a big injury or have a high value and get on the phone and treat it as if it did. There's been cases where people have lost their limbs. There's one in particular in New York where a man was working under an elevator, fixing it. By accident, the person he was working with hit a switch that caused the elevator to fall down and cut off his arm. And he tells how while he was under there, he was trying to reach for his phone to call for help, not realizing that he didn't have the arm of which he was reaching for the phone. And people had told me that there was no case because it was a workers' compensation case happened while he was working. I got to know him really, really well and spent countless nights reading different cases and different laws. What's interesting about that particular case is that on March 13, 2020, a Friday in Brooklyn, I stood up before a jury to give an opening statement for that case. Courtroom was packed. I probably had 50 blow-ups, models, witnesses lined up. I don't know what it cost me to prepare a case like this. You needed elevator experts. You needed amputee experts, neurological experts. I mean, it was insane. Standing there, I get up, and the judge said, Mr. Ripka, have a seat. And I said, Judge, I've never delivered an opening statement sitting down. And everyone kind of giggled, and it broke the ice. And you never will have to. I just got a text from the chief judge to abandon the courthouse with some kind of disease, COVID thing going on. So I sat there thinking, oh my God, I looked at him. He was in complete shock because he had waited so long. I kept thinking, oh my God, this was it. All the money, all the preparation, all the people, all the everything. Packed up myself, couldn't even wheel it out of there. And had to wait another 2 years in which to continue prosecuting that case. Well, that matter, whatever it was resolved 2 years later. Because of what I went through and what he went through, that case had a massive impact on me. But many of the other amputation cases, the children cases, the death cases, the cancer cases, they are very difficult because I am unable to separate myself from the victim and the family. Because in order for me to do my very best, I need to be one with them. We need to be a team. I need to understand them, who they are, what they are, how did we get here? And through that, if you have half a heart, half a soul, you can't help but to feel and experience what they do. But I've learned that embracing that and delivering a direct across an opening and closing statement to a jury, they get that too. And that gives your client, your injured victim, their best opportunity to be heard, their voice, who they are, not who I am. Lawyers think that juries want to hear about who they are, what they look like, what they sound like. It's none of that. And if any lawyer is convinced it is, they haven't been around long enough or haven't been slapped across the face by smart judges and jurors who say, we could care less about who you think you are. You have to step out of who you are and be them and deliver why you're there and why they deserve compensation, and why compensation is the only thing we have in our society today in which to provide someone something to make up, if you can do such a thing, for what they've endured. You know, I represent people in the military. There was a law that was changed called the State School Act. For 100 years, if you were in the military, you were not permitted to bring a lawsuit for medical malpractice. Were not. In fact, you can't bring a lawsuit for anything. Zero. It's like workers' compensation. And the law was changed in 2020, which allows active military people to bring medical malpractice cases against the Department of Defense. I represent all those people. There's a doctrine called the Ferris, Ferris. This is an exception to the Ferris doctrine that allows these people. So now, anytime someone has a case in medical malpractice, they come to me and I follow all the steps and I bring their cases for them to success, which no one could ever do for 100 years. It's interesting because representing active military people against the Department of Defense is so new. And you can imagine that lawyers for the Army, Navy, or Air Force, they're separated like that.
Right.
And what happens is that they have never had to deal with a military person bringing an action against the DOD because the military is chain of command. You think something went wrong, you tell the person above you. You don't go outside military battles. So now here comes me, and all of a sudden I'm now prosecuting civilly against these doctors and healthcare providers that are on base. And interestingly enough, there's never been a sheriff in town, right? So doctors' medical records, they never ever had to turn them over to lawyers.
Right.
Now, if you come, let's say your girlfriend or boyfriend is in the military, you go visit, and you end up in the hospital because of appendicitis. If something goes wrong, you can bring a case against the federal government, and that's an FTCA case.
Right.
And then the doctors turn over the medical records about what happened to this civilian. But they've never once turned medical records over to any lawyer for an active military person. And there have been cases such as people that, just like civilians, that go in with cramps in their stomachs, and they're told to man up and go back to work, and they have colon cancer and die. There's someone who was doing helicopter training, hanging from a rope, fell, thought he hurt his foot and back. They told him he was perfectly okay. It was a sprain, and he wound up having a massive serious injury debilitating him. There was someone who was depressed and under those circumstances did not get the medication they needed because they were told that get strong and deal with it, and committed suicide. I can go on and on and on about these cases. There's a lot of also younger doctors in the military. Think about you're a doctor, you join the military, you're in these military hospitals. And I don't know the type of training you get or how experienced physicians are in these military hospitals. I'm on the outside getting phone calls from people from all branches of the military. We had one just today. I was talking to them on, it's like a silly one, I hate to say, where a guy had congenital warts in his groin, and they burnt him off so bad that it caused massive third-degree burns and massive scarring for the rest of his life. So, interestingly enough, these are the very same cases that are out there in our everyday life, but you happen to be in the military. And there's an interesting dynamic I want to give you that I've come to understand, which is we're asking the very people that enlisted these people to serve our country, to save our freedoms, to put their life on the line, to now compensate them for something that their healthcare providers did. As you may know, the name of the law is the Stayskal Act, Stayskal. And this one was the reason for the case. You asked me about a case. He was going to go to underwater training, and they have to clear you. They took a CAT scan of his chest, and they determined that there was nothing there. He was clean, but he failed the training. Months later, he came back, and they looked at a new CAT scan, and he now had a big lump of cancer in his lung. They compared the first CAT scan and the second CAT scan, and they saw that there was a peanut-sized shaped tumor in the lung that they had failed to see. That case was born the Stayskal Act, and it was fought for a long time, and it was finally signed into law. Trump actually signed it. This is the actual law itself.
Uh-huh.
And this is... and it's dated here December 20th, 2019. And this was the actual law that allowed medical malpractice claims by members of the uniformed services. And we do this each and every day. And it's tough because the rules are tight. You don't go to court with this, by the way. There's no courtrooms. This is not like FTCA.
It's just a judge.
It's no judge. Get a load of this. You submit affidavits of experts, medical records, any other evidence you have, and there's a group of people. And guess what? They represent the Army, Navy, and Air Force. But if we have an Army case, the Stayskal was an Army case. You submit a case, that person drops off. And the other people decide if it's a case. How do they do so? They tell us that they get a doctor. We're not allowed to know who the doctor is. We're not allowed to know what the affidavit says at all, zero. But they get ours. And they, on their own, decide whether or not they believe we have a case and what the value is. And there's a cap of $750,000 for pain and suffering. And economic damages is no cap. So can you imagine? I get a letter. Sorry, no case. There's nothing I can do. There's some sort of appeal process, but it's amongst the military, of which they're never going to reverse themselves.
Right.
But we are making progress and moving things forward. And there's been a lot of denials, but we are not giving up. We're fighting for all these people every day. Every day.
And the State School Act was from your client and matter and case?
Yes. Richard Stejskal is from this law firm. That's correct.
And you even have like the official Donald Trump law that you were even holding up like Donald Trump.
That's right. Just like that, with that black marker that he signs, here we are. Yes. And, to me, whenever victims have the ability to make a claim, I'm happy. Whether or not they're right is a whole different ballgame. And I don't sit here claiming that just because you're injured, you have a claim, right? You need two things. Someone has to be responsible for your injury, and you have to have an injury that was caused by the responsible party. And that's not always the case. You could have people that make horrible mistakes and have accidents, but you're not injured. You could have massive injuries, but they weren't caused by somebody else. And, when you get more experience, you have to be able to, with some level of sophistication and sympathy and compassion, of being able to tell a client that, make them understand why the law is what it is. And I think people want to hear that from someone experienced, right? Someone who's been around and is not giving them a lot of BS to get them out of the office.
At CloudLex, we understand the unique demands and opportunities that personal injury law firms face every day. That's why we've built a comprehensive platform designed exclusively for personal injury law. Our seamless case management, AI engine, litigation support, and record retrieval solutions empower you at every stage, from intake through settlement and beyond, helping you stay productive, organized, and focused on achieving successful outcomes for your clients. Explore what's possible at cloudlex.com. Now here is this episode's closing argument.
Being a trial lawyer was the greatest gift I could have ever been given by God and my family. The reason for that is my greatest attributes, the greatest skills I have, is speaking on behalf of other people that don't have the ability, the know-how, the license, or the training to do so. And whether you're the public or you're other lawyers, standing in the shoes of other people is a privilege. We're no better. No lawyer is any better than any client they represent. In fact, they share the very same interests. One just happens to have the ability to speak for the other. From the beginning, I just wanted to be certain that I never left anyone behind, that I did all I could, whether I could afford it or not, whether I was tired or not, whether I had to be creative, whether I had to call experts, whether I had to fly somewhere, drive somewhere, sleep somewhere, to make sure that every client would say, Alan Ripka and his firm and everyone associated with him gave me all that they have. They cared about me. They cared about giving me the best opportunity to present what happened to me, present my family, my life as a result of it. And I wanted to be sure that I did that. But in order to do that, there's no sleeping, there are no breaks, you're on 24/7. You're answering calls when you're tired and you don't want to. You're leaving affairs, birthdays, weddings when you shouldn't. You are appearing in court before anyone else and you're the last one to leave. You are reviewing transcripts, watching videos, rewriting your cross and your summation when you think you can memorize it in your mind. It's that total commitment to others. Yes, we are compensated for doing that. Many people would think quite well. But there is enormous resources, enormous financial commitments, enormous management responsibilities that go into bringing a case from the day you meet someone in need until the finish line. Every ounce of your energy, every aspect of your education should go into it. And you should be proud, as I am, that you've done all possible for all people, whether it be the people who were injured, whether it be being logical and having wisdom in court, whether it be teaching other lawyers and young lawyers about what to do and how to do it so they can care as much as you do.
That was trial lawyer Alan Ripka. Thanks for sharing your stories. To learn more about Alan and his firm, visit his website, alanripka.com. All right, I'm Chad Sands. Thanks for listening. See you next time.
You've been listening to Celebrating Justice, presented by Cloudlex and the Trial Lawyers Journal. Remember, the stories don't end here. Visit triallawyersjournal.com to become part of our community and keep the conversation going. And for a deeper dive into the tools that empower personal injury law firms, visit cloudlex.com/TLJ to learn more.